And one of those,
What?
the statute, and I'm sorry, let me refer the court to the statute so that we can follow the statute.
I thought you meant your petition, but it certainly sets forth a lot of things.
Well, it does, Your Honor, that it does. If Your Honor would look to, this is chapter 112, 532, 4A. Notice of disciplinary action. A dismissal, demotion, transfer, reassignment, or other personnel action that might result in the loss of pay or benefit, or that might otherwise be considered a punitive measure, may not be taken against a law enforcement officer or correctional officer unless the law enforcement officer's correctional officer is notified of the action and the reason or reasons for the action before the effective date of the action. That's very clearly set out as one of the, and we know that from, Your Honor, from section 534 subsection E, that it's the responsibility of the compliance review panel to determine whether or not the investigator or the agency intentionally violated the requirements provided under this part. So if that was the case, if what they argued to you was correct, then the court would have to strike out dismissal, because dismissal comes, investigation's over, policeman's bill of rights, there's no opportunity to have that compliance review committee review that. And so the court would have to strike out dismissal as one of those enumerated rights. The word dismissal, very first word they use. That is in and of itself shows that they contemplated there could be a firing, and the firing could be as a result of a violation, and then a policeman or officer would have a right to have a committee review that. Next, in the next section, subsection 5, right below that, retaliation for exercising rights. No law enforcement officer or correctional officer shall be discharged, disciplined, demoted, denied promotion, transfer, or reassignment, or otherwise discriminated against in regards to his or her employment or apportionment, or be threatened with such treatment by reason of his or her exercise of the rights granted in this part.
Right, and if either of these events occurred, or any of these things occurred as described, as you just read in 4A or 5, you can bring that up before the personnel review board, can't you?
No, you can't, because you cannot, you can say, look, they fired me inappropriately, but you cannot go back and have a compliance review board take evidence and hear and determine whether these violations are intentional and violations. They go to...
It doesn't matter whether they're intentional. If they did these things you just read, it doesn't, I don't think it requires it.
It does. It requires, Your Honor, it has to be an intentional violation. It can't be an accident. In other words, we just forgot. But both of these provisions are things which were asserted as one of the bases for Captain Gardner's. So right here it tells you, if we fire you and it's retaliation, it's over. But, again, the plain language of it says that the compliance review panel has the responsibility to go and review, determine whether an investigator or agency violated this part. So you have that opportunity to do that. And again, because it challenges the investigation, that goes well beyond the personnel board. It goes on to your next employment. It goes on to the Criminal Justice Standards and Training Commission on whether you can maintain your license to be a law enforcement officer. All of those will become relevant in determining whether or not you can continue with employment somewhere else, if that be the case. It may not change anything with the county. We don't know that it will. But it certainly will change what will be his reputation from this investigation. Some panel will be charged with that sole responsibility of determining whether or not these have merit. Whether or not the personnel board agrees with them or not, or whether or not this panel makes those findings. It's a procedure used the process of this is to ensure the investigation is done fairly, and the standards and the rights are set out very specifically. And the fact that they can do it in a personnel board, or they can argue that they shouldn't consider the investigation because they violated these statutes, is immaterial. Another section where they talk about, again, disciplinary. This is the section that was in the case, but the next section, again, is except as provided in this subsection, disciplinary action, suspension, demotion, or dismissal may not be undertaken by the agency against a law enforcement officer for any act, omission, or other allegation of misconduct if the investigation or allegation is not contemplated within 180 days after the day the agency received notice of.
Right,
Yeah.
and where does it say that no one may be dismissed unless and until a review panel, compliance review panel, has been appointed and completed its work pursuant to 112.534?
It doesn't say that, Your Honor, you're correct. It doesn't say that you can't be fired. It doesn't say that you can't be fired at any of that point, but what it does say is if you do this, if you as a political subdivision do and violate these rights, an officer has a right to, if he timely requests it, to have a compliance review panel review and hear evidence.
But you don't see any difference between a provision that says dismissal shall not occur unless and until the officer is notified. A dismissal shall not occur by reason of exercise of rights guaranteed in the terms of
Retaliation, that portion related to retaliation.
Cannot do it. And another provision that says, if there's an ongoing bad investigation, intentionally bad, a compliance review panel can recommend or make findings to that effect, and the head of the agency shall remove the offending investigator. It doesn't say anything about termination.
It doesn't say anything, but what it does, and again, the section that I talked to you about earlier, it says that it's the responsibility of the panel to determine violations by investigator or agency. It may be an investigator, and if it is an investigator, the statute's very clear on how you handle and deal with investigators. It's very clear.
Well, what does the Personnel Review Board do?
Personnel Review Board determines whether or not, under the policies and procedures, whether or not there's been, as I understand it, and again, whether or not the discipline initiated by the county is appropriate based upon the evidence that they've collected or the determination of those violations. In other words, as I understand it, there's a ranking of different disciplines that could be dismissals, obviously at the top, nothing would be at the bottom, and then there's a variation there. And the Personnel Review Board is if you want to call it, is a check in between the administration to see, do we have grounds for dismissal? Based on the findings of your investigation, do we have grounds for dismissal under our current policies and procedures? But they don't, the investigation itself is done. We can argue, well, it wasn't valid, but that's something that from the investigation standpoint is a due process that we're allowed and that we have to, according to the McQuarrie case, have to establish and the right to, through the circuit court, ultimately with an injunctive relief. It's not to be done at the Personnel Board. Personnel Board then takes whatever investigation is left, if any, and then makes a determination, is that discipline appropriate? And maybe in this case, they may say, well, it is, or they may say it is. But the investigation itself, according to McQuarrie, should not be done at that Personnel Board. It should be done appropriately at this review board for the specific
I
element.
need to be picky about this. When you're saying McQuarrie, you mean McQuaid?
Yes, Your Honor.
Okay, well,
I agree, Your Honor. It's McQuaid.
I don't want some judge or clerk or otherwise to be screwing around looking for a non-existent case, that's all. Okay.
McQuaid
I want
is,
to make sure I wasn't overlooking
no, McQuaid is specifically 51 Southern 3rd.
it. Okay, well, I thought that's what you were talking about. I didn't mean to be. All right. Anything else at this point? Any other cases that you would direct me to other than McQuaid and perhaps Migliore and there was one other one there that someone directed and we discussed today. Let's see. Yes, there is. City of Miami versus Castro is the one I was thinking of. So those three I know we talked about today, and everybody cited things, but anything else that you think you would want to bring to my attention that you think would really inform me in making this decision?